217.
Yes, 217.
217, yes.
The last para begins like this. In view of the same, partners resolved as follows. The Lordship finds that it's the resolution of Raghav Reddy and Sons.
Raghav Reddy and
Associates.
27. Both the parties have decided to settle.
Yes, Manoj. That's para.
Yes, yes.
Para, kindly see the last line, Manoj.
Yes.
Being an area of 10,000.
Yes, yes, yes. That is
318 square feet.
yes.
Earmarked in the sketch annexed to the compromise petition shall be retained by the People Charity Fund.
Yes.
Now, our compromise with them is, I will get 6,000 and odd. I will return this to you. You keep it. So I have recorded that they are going to retain it.
Yes.
But please see, my lord, what the trust says. The trust resolution
Yes.
is at 207. I had pointed this out to your lordships. My learned friend apparently did not refer to this.
Yes.
Page 207. There are 3 paragraphs relating to sale of the property, my lord. Starts at 207. They give the history, last para in 207.
Yes.
The trust has been advised in the present litigation appeal likely to consume more time, possession, no benefit, past 40 years litigation,
Yes.
no possibility of getting any income.
Yes.
Raghav Reddy are in possession. At the end of long drawn litigations involve expenditure time, it is advised that possibility of the trust getting substantial benefit and associates other than what is stipulated is very remote.
Yes.
Proposal has been negotiated where Raghav Reddy will retain 6,000 out of 16,000. Substantial portion will be surrendered, returned back to the trust. This will enable the trust to raise substantial funds to fulfill the objectives and activities.
Yes.
Lord, I would only understand this like this, my lord. What will they use this for, my lord? This is a charitable trust.
Yes.
It's a vacant land. It has nothing on it, no structure, no building. I can understand if there's a building, they can let it out, get some rent. It's vacant land, which they're getting after this 25, 30 years of 40 years of litigation now. So they take this, then noting this, please go to next para. The proposal was discussed, debated in the background of legal financial advice taken by trustees from the advisors. All pros and cons identified, weighed and debated. Trustees have taken advice of legal luminaries who have held responsible position. Then what? Next para.
Yes.
About 5 lines from the end of that.
Yes.
It K. Raghav Associates, in view of the said entity giving up its claim to the entire property, the balance area being an area of 10,318 square feet, earmarked in the sketch annexed to the compromise petition, shall be sold by the trust.
Yes.
To raise funds for setting off expenditure for generating funds or finances to undertake further charitable activities in a larger scale with wider reach.
Yes.
This is what I respectfully place for your lordship's understanding, Lord. My last date, my learned friend has no answer for this. Absolutely nothing about this. So this is a resolution of the charity, and your lordships have already seen the case law, my lord, on the question as to what is the power of the trustees to do this. Now, my lord, flippantly, my lord, with due respect, I'm submitting. Very sarcastic submission was made that, oh, you'd compromise, you'll sign aito, court corridor alli yaro duddu itkondu ready agidru, adike sell deed madibitru anta. My lord, that is completely unjustified. If you see this resolution, my lord, this resolution is compromise petition.
Yes.
And, my lord, your lordships may take note of the fact that a compromise like this, my lord, involves several parties.
Yes.
And if a third party, my lord, comes and says, I am going to take this property, I am going to fund the trust in this manner, if you settle with Raghav Reddy and they take a decision that they should settle, instead of 16,000, they get 10,000. Instead of 16,000, I get 6,000. So it is a win-win situation for the trust. They have got everything that they can think of with no litigation whatsoever. And they have, if there was no buyer, if there was no negotiation, if there was nothing, I asked myself, how could they pass a resolution on 6th February? The absolute statement is made in the resolution of the trust. What I say, my lord, I am a third party. I say they're going to retain it, but they say we're going to sell it. This was before your lordships, my lord, is my respectful submission. Lord, the last point which my learned friend made, kindly take the statement of objections.
Yes.
Page 51.
Objection in which?
in RP 226. Number RP 226 ಅಲ್ಲಿ objections filed by the other side. The same thing what is there in the resolution. This is the document, my lord, under which the trust
Yes.
the objections of respondents 1 to 3.
Yes.
The sale deed under which they sold it, my lord,
Page number?
43. It begins at 43. It is
Yes.
dated
Yes,
15th February 23.
Yes.
Registered, my lord, on the same day.
Yes.
It is in favor, my lord. Next page, your lordship. First page, your lordship, people charity represented by so and so.
Yes.
Second page, my lord, in favor of
Yes.
building blocks INC
Yes.
represented by so and so. He is the purchaser.
Yes.
My lord, in this registered document, kindly turn to page 51. They have actually put down in writing what
Yes.
the resolution of the trustees was. The para number 8, my lord, Roman number 8. The seller Raghav Reddy Associates were not able to fully conclude the litigation despite several years and incurring huge expenditure. Seller was not able to derive any income from larger property. Raghav Reddy was in possession, was unable to develop the larger property in view of the uncertainties in the litigation. At the intervention of well-wishers of the parties, professional advice in the interests of the seller and K. Raghav Reddy and Associates, and decided to amicably settle the disputes. Then we're not lower down in that. They say the larger property is described in schedule here under, hereinafter after schedule property, which the seller trust has agreed to retain for itself. In terms thereof, the seller trust agreed to fully and finally settle the compromise their dispute. The seller have recorded the aforesaid settlement arrived between themselves in terms of the compromise before the Honorable High Court. Then, my lord, next same page, last two lines. Therefore, the trustees of the seller trust, after evaluating all circumstances, by its resolution dated 6/2/23, taken a decision to liquidate objectives and purposes of the trust to undertake charitable activities in a larger scale to ensure wider reach. Seller has come forward to sell the property,
Yes.
purchaser on the other, then operative portion. And the trust, my lord, under this document gets 12 crores 37.5 lakhs. Your lordship,
Yes.
see that consideration at page 54.
Yes.
No, in a situation that the trust had nothing, by this compromise, this is what the trust obtained. Now, my lord, the submission is that this is a fraudulent one. My lord, on that, my lord, we already addressed your lordship. This trust selling property is never fraud, unless they make out something, and for which they have already filed a case. So they can't again, my lord, re-agitate that matter. The last submission, my lord, was more a submission on sympathy
Yes.
to say that the court is a public charitable trust. Therefore, the court is the patria paternus of this, and court has every right to look into everything that is done. Now, my lord, the Honorable High Court exercising jurisdiction in a first appeal is different from the Honorable High Court exercising jurisdiction in a first appeal from an order or a judgment under Section 92. 92 order, my lord, under Civil Procedure Code, if they go against a trust and the district judge, learned district judge, my lord, is pleased to accept and pass some order, then when the matter comes up in appeal, your lordships are continuing the proceedings there. So the wide discretion which was available before that court is very much available to the appellate court as appellate court. But not today, that discretion, that jurisdiction is not what your lordships are exercising. Your lordships are not seeing the conduct of the parties here. Your lordships are not seeing what is this trust, why is it selling. All that can be done in those proceedings. Supposing, my lord, the trust sold the property without following any procedure. Suppose it sold at 50% of market value. This can be examined there. But that's not the case here. No such allegation is made.
Yes.
And that jurisdiction is not being exercised.
Yes.
Therefore, my lord, that should not come in the way of your lordships for entertaining. The last submission, lord, he relied on a judgment of the Supreme Court in 2022 SCC online.
Yes.
1034, Madhusudan Reddy's case. There, my lord, a CRP order was made.
Yes.
That is challenged in review. A review was dismissed. A second review was filed.
Yes.
So, my lord, that judgment is not of any use because here it's not a second review. There is one order passed by your lordships. That order, my lord, is sought to be now reviewed in this application. So, this judgment will not come to that. I'm grateful. My lord, what has happened is now with this order and the compromise, 3 other proceedings got closed.
Yes.
There's a suit filed by me, there's a CRP, and there is the first appeal. Now, my lord, if this order stands, then I neither have the property, I neither have the asset, I neither have possession, and I neither have litigation. So there is nothing that I can do except to just walk out with the empty hands after 40 years of litigation. That could never be, my lord, your lordship's intention. Therefore, my submission, my lord, is that that issue may have to be re-examined by lordships is my respectful submission. I confined myself to only one point, my lord. Though a number of issues were argued before your lordships confined it to one point. That point is, you said you're going to retain, but you're selling it, you sold it. Therefore, this is not a fair thing to do. For that, my lord, there's material now to show that it was always disclosed and there was nothing secret or hanky-panky about it. There's no fraud whatsoever. And they've not alleged fraud also, at least not in these proceedings. Great.
Yes. Yes, resort. You want, I thought that one. Yes, yes. Yes, yes. No, when it started 2:30, I saw only Naganan. I thought that. Yes. Yes.
My lord, first of all, my lord,
Yes.
please look at, my lord, the review petition itself. Page Tao, review petition which they had filed, my lord. Please look at the pleadings. I'll tell your lordships why.
Yes.
My lords, get that. The pleadings, my lord, in the review petition. ಪೇಜ್ಗಳು ಏನೇನು ಹಾಕಿದ್ದೀರಿ ಸಾರಿ ಬಂದೆ ಇದೆ ಇಲ್ಲ ಅವ್ರ ಪೇಪರ್ ಯಾವ ಪೇಪರ್ ತಗೊಂಡಿದ್ದೀರಿ ಯಾವ ಅವ್ರದ್ದ ಬಿಕಾಸ್ ತಾವು ಒಂದನ್ನು ಯಾವ್ದಾದ್ರು ಒಂದು
2 to 6.
2 to 6 ಯಾಕಂದ್ರೆ ನಮ್ಮ 230 doesn't matter. I'll
Review petition.
Very well. I'll just tell you.
That is. Okay.
Lord, I'll just tell your lordships.
Yes.
Their main grounds are, my lord, 4 in number. Please come to my lord. Running page 269, my lord. 1 minute.
269.
Idalre.
269 alla.
My lord, the 274, my lord, is review petition starts. 276 bani.
Yes, that is correct.
My lord, 4 grounds are raised.
Yes.
I'll tell your lordships why.
Yes.
A person, my lord, cannot, my lord, go beyond the pleadings.
Yes.
First ground is, suit filed, my lord, is not maintainable since it is barred by limitation. First ground avaradu.
Yes.
Please look at, my lord, clause 1. Ground only 1 first para.
Yes.
Second, my lord, contention that they have raised is,
Yes.
there is nothing to show that the second trustee has joined, my lord, in the compromise.
Yes.
This is the second contention. Third contention is that, my lord, there is an error apparent on the face of the record because they are giving up, my lord, they are giving a no objection. Compromise ಬಗ್ಗೆ ತಾವು, your lordships are not satisfied anteli.
Yes.
Third contention. Fourth contention is, having regard to, my lord, the history of litigation, there is a sudden change of heart, therefore, the, my lord, it is not bona fide. 4 contentions bittu ಬೇರೆ ಯಾವುದು ಇಲ್ಲ.
Yes.
First submission of theirs was,
Yes.
my lord, we are my lord, we are beneficiaries. Not a, my lord, whisper, my lord, in the entire, my lord, RP,
Yes.
saying that they are beneficiaries. If that is so, my lord, what they have, my lord, argued and which your lordships, my lord, found to be correct, is on the face of it, my lord, is not tenable. First two. Secondly,
Yes.
your lordships held, my lord, that they are trustees because under the will, my lord, they are trustees. My lord, they are, my lord, beneficiaries. They are not beneficiaries of this trust. Some different property is given to them, my lord. Please look at the will. Will hakidara avaru. Our will hakilla.
Yes.
Our will hakilla. And, my lord, in the entire pleading, my lord, as hakidira yav torsi.
Along with the review.
ಕಾಪಿ ಕೊಡ್ಲಿಲ್ಲ ನೀವು, ಡಸಂಟ್ ಮ್ಯಾಟರ್.
ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದೀವಿ ಸರ್.
ಆಯ್ತು ಇರ್ಲಿ, ಡಸಂಟ್ ಮ್ಯಾಟರ್.
Yes.
ನಿಮ್ ಕಾಪಿನೇ ತಗೊಂಡ್ರಿ.
ಬಿಲ್ ಹಾಕಿದ್ದೀವಿ ವಾಲ್ಯೂಮ್ 3 ನಲ್ಲಿ.
ಆಯ್ತು, ವಾಲ್ಯೂಮ್
Volume 3 ನಲ್ಲಿ.
ಕೊಡಿ.
Volume 3 of the documents filed in RP. RP.
RP ನಲ್ಲಿ ಹಾಕಿರೋದು ಇಲ್ಲಲ್ಲ.
Yes.
ಮತ್ತೆ ಆಯ್ತು ಇರ್ಲಿ,
Yes.
ಡಸಂಟ್ ಮ್ಯಾಟರ್. ಪ್ಲೀಸ್ ಹ್ಯಾವ್ ಮಲಾಡ್ ಅವರು ಫಸ್ಟ್ RP ನಲ್ಲಿ ಅವ್ರು ಏನೋ ಡಾಕ್ಯುಮೆಂಟ್ ಹಾಕಿದ್ರಂತೆ ಸ್ವಾಮಿ. ಪ್ಲೀಸ್ ಕಮ್ ಟು ಮಲಾಡ್. Will is supposed to be at page 151.
Yes.
ಇಲ್ಲ 151. Yes. Correct. My lord, not a whisper. They are, my lord, beneficiaries under this trust.
Yes.
What is not there, my lord, I can't show.
Yes.
Please come to my lord. If your lordships look at my lord,
ಇದಲ್ರಿ ಹಳೆದು.
page 156 ಬನ್ನಿ ಸ್ವಾಮಿ. ಅಲ್ಲ, ಹಳೇದನ್ನು ಹಾಕಿದ್ದಾನೆ ಅಂತಾರೆ, ಇಲ್ಲಿ ಹಾಕಿಲ್ಲ.
ಇದ್ರಲ್ಲಿ
ಸರ್, ಬೇಕಾಗಿ ಬಿಲ್ ಅನೆಕ್ಸ್ ಆಗಿರೋದು ಬಿಲ್ನೇ ಕಾಪಿ.
ಗೊತ್ತಾಯ್ತ್ರಿ.
159 ಅಲ್ಲಿ 23 ಕಲಿಯಾಣ.
ಬಂದೆ.
RP 235.
235 ಅಲ್ಲಿ ಅವ್ರೇನೋ ಥರ್ಡ್ ವಾಲ್ಯೂಮ್ ಹಾಕಿದಾರಂತೆ ಸ್ವಾಮಿ.
Volume 3. There are 4 volumes.